Welcome to the Arizona State Library Archives and Public Records presentation on the public and records regarding requests, transparency, and accountability with the public in mind, brought to you by the Records Management Branch and presented by me, Aeneas Santiago, the Records Management Specialist in our small unit. The Arizona State Library Archives and Public Records is a subfunction of the Secretary of State. Some contents of this presentation have been created with reference to Sarah Thornhill, City Clerk of Prescott's presentation to AMCA on Arizona Public Records in 2025. The presentation was also verified by the Ombudsman Citizens Aid Office. What I hope to cover today will be used by those responsible for receiving public records requests or conducting records management duties that are public-facing. Today we'll be covering an agency's relationship with the public and how that relationship directly affects the records we create and maintain. We'll discuss why those records are considered public records, walk through a few real-world examples, both positive and negative, of how public records have been used, and touched on commercial use of public records and the exceptions to disclosure. We'll also walk through the public records request process from start to finish, the fundamentals, the timelines, fees, and practical tips that help requests go smoothly. Finally, we'll talk about the importance of internal policies and procedures, not just for public records requests, but for other public-facing interactions that generate records. We'll close with resources and contacts you can rely on if questions come up or a situation becomes complicated. Sometimes our interactions with the public can feel inconvenient, repetitive, or even frustrating, depending on the nature of the interaction. Depending on our role as record keepers, we may even lose sight of our direct relationship with the public altogether. Some records positions involve face-to-face interactions at a service counter, but others may involve working quietly behind the scenes in offices, archives, or systems most people never see. Regardless of where we sit, it's important to remember that a government agency is, first and foremost, a public agency. The ultimate purpose of any public agency, whether it's law enforcement, finance, a regulatory board, or a road improvement district, is to serve the public in some capacity. Even organizations that receive or administer public funds, even partially, typically fall under this same umbrella. As public agencies carry out their daily work, they produce records as evidence of this work being done. These records document services provided to the public and the supporting functions behind them, such as human resources, legal review, budgeting, procurement, and administration. Because of that, the records we create are by default public records. That responsibility means agencies must maintain records in suitable conditions for inspection. If someone were to walk in and ask to see a record, the response should never be, "Are you sure it's damaged?" or "There's coffee spilled on it," or "We can't find half the pages." Maintaining records properly is part of our duty to the public. Think of records as just one variable in a larger system. That system is public service as a whole. When the public identifies a need, something they cannot or should not handle on their own, government steps in to provide a service. Proof that this service was provided is created in the form of records. These records are then stored in a system for a reasonable period of time, based on retention schedules, waiting to be accessed by the public or other stakeholders. The quality of those records or how accessible they are directly affects how the public evaluates the quality of the agency's work. The public relies on agencies to meet needs that may be out of their control, while agencies rely on the public to evaluate their own programs, provide feedback, conduct research, ensure accountability, and sometimes challenge decisions. This relationship is mutually dependent, and records sit right at the center of it. The biggest consequential challenge agencies face is that in most cases we are not entitled to know why someone wants a record. The major exception to this is when a record is requested for commercial purposes, meaning it will be used to generate profit. In those cases, agencies may request a statement of purpose and apply additional fees as allowed by law. Executive orders and statutory authority provide protection in cases where a request appears malicious or deceptive. Outside of commercial use, however, we often don't know how records will be used. They may be used for education, research, journalism, oversight, or personal reasons. They may also be misused for fraud, harassment, misinformation, or exploitation. Because we cannot predict intent, every request should be handled carefully, consistently, and in accordance with the law. There are real examples on both sides. Scammers have impersonated public agencies and used publicly available information to commit fraud. At the same time, public records have exposed significant wrongdoing. For example, in 2023, a multi-billion-dollar Medicaid fraud scheme was uncovered through a combination of agency investigation by Access and public records requests by journalists, eventually reaching the federal level of investigation. On the other hand, though, agencies themselves have faced scrutiny for mishandling public records. In 2014, the Auditor General issued an alert warning against falsifying records in response to requests. More recently, allegations arose in 2025 regarding withholding records related to communications with federal immigration authorities. These examples are not about blame or our relationship to the federal government. They just illustrate how seriously public records are taken and how widely their handling can be scrutinized. While records are generally public, not all information within a record can be automatically or easily released. A good test is to consider whether you would want your own sensitive information, such as personal identifiers, medical details, biometric data, or securely related information, released to an anonymous requester. The law provides clear guidance on categories of information that should not be disclosed. These include, but are not limited to, archaeological site locations, telecommunications infrastructure details, student records, medical and mental health records, juvenile and crime victim information, and certain law enforcement or security related materials. This is where legal counsel and internal policy become critical. Rather than outright denying access, agencies should withhold or redact only the protected portions of a record whenever possible. While this can feel intimidating or seem like a lot of work, the law exists to support reasonable, common sense decisions when applied correctly. All of this underscores the importance of diligence. Record staff and anyone involved in releasing records must take care not to become too complacent, especially when handling high volumes of requests. Sloppiness or shortcuts are often what lead to legal issues. Retention schedules are a major part of this risk management. If records that should have been destroyed are still in your possession and are responsive or subject to some kind of request and its scope, they must be treated the same as any other record and released if not exempt. This is why proper disposition is just as important as proper retention. With that foundation in mind, we can break the public records request process into four main areas: basics, timeframes, fees, and additional procedural considerations. Records must be maintained as if they could be inspected at any time during regular business hours. Agencies must follow approved retention schedules and ensure records are organized and retrievable. Each agency must designate a person, office, or function responsible for handling requests, with contact information made publicly available. Many agencies use online request portals which can help automate intake and tracking. Agencies must also have a method for copying or allowing inspection of records. If a requester is making their own copy, supervision may be required to protect the integrity and use of the record. Internal policies and legal guidance help ensure consistency and prevent errors. Timeframes matter for two reasons. First, requests must be acknowledged within 5 business days if an automatic receipt is not generated. The requester must be told who is handling the request and how to contact them. Second, records must be provided promptly, meaning without unreasonable delay. The time required should be proportional to the size and complexity of the request. Small requests may take days, larger ones may take weeks, but in all cases, communication is key. Setting expectations and providing estimated timelines helps avoid misunderstandings. When records become available in stages, it is often best practice to release them as they are ready rather than waiting for everything to be completed. Certain fees are legally allowed, such as reasonable copying and postage costs. These may be requested in advance. For commercial requests, agencies may charge additional fees for staff time, materials, equipment use, and the market value of the record as determined by the agency. Some records must be provided at no cost, including in-person inspection, records needed for interacting with federal benefit programs, and certain law enforcement records for victims or their representatives. Agencies must be especially careful not to charge unauthorized fees or fees that are not designated in law. Agencies should also agree with the requester on the format of the records provided. Providing a record in an unusable format undermines access. While the substance of a record should not be altered, converting it into accessible formats like PDFs, PDF-A, TIFF, or images is generally acceptable. Up to this point, we've talked about public records at a conceptual level, what they are, why they matter, and where the legal boundaries are. This slide is our blueprint, just like some of our other presentations, aka where all of that becomes operational and answers the practical question, what actually happens once a public records request comes in? To keep the process manageable and defensible, it helps to think of it in two separate blocks. The first one is reception and assignment, and the second is handling and response. Each block has its own responsibilities, documentation requirements, and risks if not handled carefully. Public records requests can arrive through many different channels, that being an online portal, email, physical mail, and an in-person request at a service counter. Regardless of how a request is received, the first requirement is consistency. Every request should be treated the same and logged into some kind of centralized tracking system. At a minimum, the log should capture the date and time the request is received, the requester's name and contact information, a clear description of the records requested as is, and whether the request is indicated or suspected to be for commercial purposes. This logging step is not just administrative busywork, it establishes a timeline and record of compliance that not only saves you, but is relied upon later by legal counsel, auditors, or a court. Once logged, the request must be assigned to a specific individual or unit. This person becomes the party responsible for coordinating the response and is the agency's official point of contact. The requester must be informed who that person is and how to reach them, typically by name, phone number, and email address. If the request was not submitted through a system that automatically generates a receipt, the agency must acknowledge receipt within 5 business days. This acknowledgement does not need to include the records themselves, but its purpose is just to confirm receipt, identify the assigned contact, and explain what will happen next. At this stage, Staff should evaluate whether clarification is needed. Requests that are overly broad, unclear, or internally inconsistent should not be guessed at. Agencies are permitted and encouraged to seek clarification, so effort is focused on producing the correct records. Importantly, the responsibility to clarify rests with the requester, though agencies should still act in good faith and not use clarification as a delay tactic. That is to say, effort should still be made while awaiting clarification. This is also the point at which staff determine whether the records are actually held by the agency, whether another agency is better suited to respond, or whether multiple departments or custodians must be involved. Clear communication with the requester during this phase prevents confusion and demonstrates good faith compliance. Once the request has been clearly defined and assigned, the second phase begins, which is handling the request and preparing a response. The first step in this phase is assessing records for legal exemptions, privileges, or confidential information. This assessment should occur before records are released or copied. Staff should rely on internal policies and, when appropriate, consult legal counsel, especially for sensitive records, law enforcement materials, or requests that could reasonably result in litigation. After legal considerations are identified, the agency must conduct a reasonable search for responsive records. Reasonable does not mean exhaustive or unlimited, it just means searching locations where the records are likely or supposed to exist, using methods consistent with normal agency operations. Searches may include physical files, electronic databases, shared drives, email systems, or records management platforms. Throughout this process, though, staff should document where searches were conducted, what staff or systems or repositories were reviewed, the date ranges searched, any limitations or constraints encountered, and this documentation ultimately is critical if the adequacy of the search is later questioned. It's also important to reiterate that agencies are not required to create new records, compile data, perform analysis, or answer questions to fulfill a public records request. The obligation is limited to providing existing records that can be reasonably identified as responsive. Once records are located, they must be reviewed carefully. Any exempt information should be redacted rather than used as a basis to deny the entire document whenever possible. Redactions should be narrowly applied and consistent with legal guidance. If multiple redactions are made or if entire documents are withheld, it is very recommended practice to create an index or explanation describing what was withheld and why. This transparency strengthens the agency's legal position and demonstrates good faith. At this point, though, any legally permitted fees such as copying or postage should be calculated. The requester should be notified of anticipated costs before records are released, and payment may be required in advance where allowed by law. Once records are prepared, they should be provided in the agreed upon format or made available for inspection physically. If any portion of the request is denied, the denial must be issued in writing and grounded in clear legal authority. Finally, all documentation related to the request, including communications, search records, redaction decisions, and final responses, must be retained according to the applicable General Retention Schedule record series. Only after that retention period has been satisfied can the request file be closed and disposed of. This process is where the most risk occurs in records management. Delays, inconsistent handling, undocumented searches, or poor communication tend to happen when the process is informal or improvised. A clear, repeatable workflow protects both the agency and the staff carrying it out. Handled correctly, this process does a lot more than just comply with the law. It demonstrates transparency, professionalism, and accountability to the public that we serve. Now let's focus on lessons we ourselves have seen when agencies deal with requests, practical guidance that helps us avoid common mistakes. First, always assume disclosure. The default assumption under public records law is access and not secrecy. Always assume to release a record until proven otherwise, or in using common sense consideration mentioned earlier. Withholding should only occur when clearly authorized by law and limited to what is necessary. Second, timeliness matters, but so does reasonableness. Requests do not take priority over all other duties, but they cannot be ignored or unreasonably delayed. Setting expectations early by explaining the estimated timeline to the requester helps balance workloads and reduces frustrations, especially on the part of the requester. Third, be diligent and thorough when searching. Incomplete searches are a frequent source of legal challenges. Even if no records are found, documentation of every part of the search effort is essential. Fourth, ask for clarification when needed. If a request is unclear or unmanageable as written, clarification protects both the agency and the requester. Applying reasonable limits is allowed, especially when records no longer exist due to retention, for example. Fifth, charge only legally authorized fees and provide advance notice of what those might be to the requester. Unauthorized or excessive fees can quickly escalate into complaints or litigation. Sixth is agree on format. Providing records in a format that the requester cannot access is functionally equivalent to denying the request in the first place. Use commonly accessible formats unless doing so would alter the record's substance. Seventh is communicate consistently and courteously. Clear communication prevents misunderstandings and often diffuses tense situations before they escalate. Finally, create records as if they are reviewed publicly. Records may be examined by the subject of the record, or oversight bodies, or journalists, or courts, but sensitive issues, therefore, should be escalated appropriately so the decision does not entirely fall on you. Now for one of the most difficult scenarios an agency can face. What if the record was lost? If a record is discovered to be lost or missing, staff should immediately consult legal counsel, executive leadership, and applicable policy. Policy should also be changed to reflect this issue. Do not attempt to recreate or substitute a record without the proper and competent guidance. Under Title 39, certain recorded documents may be replaced by alternatives such as oral testimony, certified copies, or court judgments. However, whether that applies depends on not only the type of record and how it was originally created, but whether the document was legally recorded in a county recorder's office. This slide is also a reminder of the importance of backups, file plans, and clear record-keeping practices. Knowing where records should exist and how they are maintained is fundamental to accountability. Don't wait until the public requests something to put controls in place. It should be said that public records requests aren't necessarily the only ways in which records management on behalf of an agency interacts with the public. Many everyday processes are public-facing and record-driven, including licensing and permitting, inspections and enforcement, law enforcement and adjudications, surveys, research and reporting, public meetings, and hearings. On the other hand, the public interacts with agencies through feedback, complaints, litigation, applications, and submissions. Each of these processes generates records that must be managed according to law and policy. Understanding these broader interactions interactions, especially in the grand scheme of things, helps agencies design better systems and anticipate record-keeping needs. Public records law and records management do not have to be navigated alone. Agencies have access to the Attorney General's Office for legal guidance, the Ombudsman Citizens Aid for public-facing concerns, professional associations and peer agencies for practical examples. Working groups and shared standards can even improve consistency across agencies and reduce risks. ARS, or Revised Statutes Title 39, provides the core legal framework for public records requests, though other state and federal laws may apply. While it is manageable in length, it should be consulted regularly. In general, we can break this whole relationship down into three categories: the public and what they can do, the agency and what we can do, and exceptional situations that may not be as black and white as that. The public has access to agency records unless prohibited by law, and through that access can do a variety of things, both good and bad, but mainly uses this information for accountability or the protrusion of such, and personal knowledge. This is mostly exercised through interactions with the public-facing aspects of an agency or through public records requests or PRRs. The agency, on the other hand, makes a diligent effort to provide the records to the public when requested and must take care of its records like someone will come in physically and view them at any time, whether that be us, the Auditor General, the public, the courts, or otherwise. In the process of such requests, though, the agency can charge reasonable and legally allowed fees that can be asked for beforehand to cover cost. Otherwise, and especially in certain cases, records may be free. The agency can be exposed to serious legal ramifications should unreasonable delay take place in providing records or outright denying access to certain documents, and should have appropriate procedures in place for legal counsel on speed dial and consistent reviewer approach. Otherwise, using a record commercially allows an agency to ask for its purpose and extra costs for processing. If using it deceitfully, though, the requester can face just as serious legal ramifications as we can. If a record was lost, it depends on the kind of record and whether legally recorded or not. Either way, consult legal counsel or policy and file a notice of destruction with us, which you'll have to ask us for the template. The public's relationship with us shouldn't be overburdening. Only reasonable efforts should be made to provide records, and if conducted well, can display the integrity and responsibility of an agency overall and to its internal process. If requests for the same records occur multiple times, however, it is fine for such a record to be published so that they stop asking for the same ones. Some agencies even go as far as to publicly post certain kinds of records from the get-go: annual reports, financial data, certain court records, recorded documents, ultimately for public leisure. If that's possible, that's the way to go, but if not, expect the public records request to go something like the guide we gave. Thank you for viewing this presentation, and if you have any questions, please ask us on our website or send us an email at records@azlibrary.gov. This presentation also accompanies other presentation materials that may clarify certain areas contextually.